Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Welcome back. We have another episode of our Substantive Spotlight series where we're diving deep into the world of torts. Today we're tackling negligence, the bread and butter of tort law, and one of the most heavily tested topics on the bar exam. Think of it as the foundation of your tort law house. If you don't get this right, the whole structure might come tumbling down. What's fascinating about negligence is how it permeates everyday life. Every time you drive to school, grab coffee from that shop with the slightly uneven floor, or trust a doctor with your health, you're swimming in potential negligence scenarios. Today, we're going to synthesize the key concepts we've covered in our Listen and Learn series, and trust me, mastering these will be crucial for both law school exams and the bar. So let's start with the big picture. Negligence has 4 essential elements that you absolutely must memorize: duty, breach, causation, and damages. Think of these as the 4 pillars holding up your negligence claim. If any one of them crumbles, your entire case collapses. The first element, duty, addresses what one person owes to another. This is where we ask, did the defendant owe the plaintiff a duty of care? In most cases, we apply the reasonable person standard. Every person owes a duty to foreseeable plaintiffs to act as a reasonable, prudent person would under similar circumstances. But here's where it gets interesting. The reasonable person isn't just some average Joe on the street. As we covered in our Listen and Learn episode on the reasonable person standard, linked to in the show notes, this hypothetical reasonable person never jaywalks, never texts while driving, and always reads warning labels. They're not perfect, but they're certainly more careful than most of us on our best days. The standard changes based on who the defendant is. For children, we apply a modified standard. They're held to the standard of a child of similar age, intelligence, and experience. But wait, there's a major exception. When a child engages in an adult activity, like driving a car, they're held to an adult standard. So that 16-year-old who just got their license, they don't get a rookie discount when it comes to negligence. Professionals get special treatment too. A doctor isn't compared to a reasonable person. They're compared to a reasonable doctor with similar training. As we discussed in our Listen and Learn episodes, these professionals have a heightened duty because of their specialized knowledge. A brain surgeon isn't judged by what an average person would know about the frontal lobe. They're held to the standard of other brain surgeons. Landlords, property owners, and possessors of land also have special duties, which we explored extensively in our Listen and Learn episodes. The duty might change depending on whether someone is an invitee, licensee, or trespasser. Remember the attractive nuisance doctrine? That's where children are drawn to potentially dangerous conditions on someone's property, like an unfenced swimming pool. The law recognizes that kids will be kids and places additional duties on landowners to protect them. Once you've established duty, the next question is, did the defendant breach that duty? This is where we compare what the defendant actually did against what a reasonable person would have done under similar circumstances. In other words, did they fall below the standard of care? There are several ways to prove breach. As we learned in our Listen and Learn episodes, you might apply the BPL formula from the classic case United States versus Carroll Towing. Under this approach, if the burden, B, of taking a precaution is less than the probability, P, of injury, times the expected loss, L, then failing to take that precaution is a breach. Think about it. If it costs $100 to fix a wobbly stair railing that has a 10% chance of causing a $10,000 injury, math tells us that's a breach. Industry customs can be relevant too, though they're not determinative. Just because everybody does it doesn't mean it meets the standard of care. And compliance with statutes? That's evidence of reasonable conduct. But it's not conclusive either. Driving under the speed limit during a blizzard might still be negligent if conditions warrant even slower speeds. Sometimes a plaintiff might not know exactly how the defendant breached their duty, but the circumstances strongly suggest negligence occurred. That's where res ipsa loquitur comes in, Latin for the thing speaks for itself. As we discussed in our episodes, this doctrine applies when 1, the injury typically doesn't occur without negligence, 2, the defendant had exclusive control over what caused the harm, and 3, the plaintiff didn't contribute to their injury. Classic example, you wake up from surgery with a scalpel left inside you. You don't need to prove exactly what the surgical team did wrong. The situation speaks for itself. Let's move to the third element, causation. This is actually 2 separate tests, factual cause and proximate cause. We covered factual cause extensively in our Listen and Learn episodes. The question here is simple. But for the defendant's breach, would the harm have occurred? If the answer is no, you've established factual cause. But what if there are multiple causes? That's where the substantial factor test comes in. If the defendant's actions were a substantial factor in causing the harm, even if they weren't the only cause, that's enough for factual causation. Proximate cause is all about foreseeability and policy considerations. Even if the defendant's actions factually caused the harm, we ask, is it fair to hold them responsible for this particular consequence? The classic example is the eggshell plaintiff rule. You take your plaintiff as you find them, even if they have an unusually thin skull that cracks under a light tap. Intervening causes can break the causal chain, especially criminal acts by third parties. But if those acts were foreseeable, the original negligent party might still be on the hook. Remember, foreseeability is the key. The final element, damages, requires actual harm. Unlike some intentional torts where nominal damages are available, negligence requires the plaintiff to have suffered real harm, whether physical, property, or sometimes emotional. Now, there are a couple of special doctrines that can help plaintiffs establish negligence. Negligence per se, which we covered in one of our Listen and Learn episodes, uses a statute to establish both duty and breach. If a statute was designed to protect against the type of harm that occurred to a class of persons that includes the plaintiff, and the defendant violated that statute, the duty and breach elements are essentially checked off automatically. Now, when analyzing negligence questions on an exam, here's your attack plan. 1. Start with duty. Identify the standard of care. Is it a reasonable person or a special standard? 2. Consider any special relationships between the parties. 3. Look for statutes that might establish duty. Next, analyze breach. Compare the defendant's conduct to what a reasonable person would have done. Consider the BPL formula. Look for violations of customs or statutes. And consider whether res ipsa loquitur applies. Then it's time to examine causation. Start with but-for causation, then consider the substantial factor test if needed. Analyze foreseeability for proximate cause, and look for any intervening causes that might break the causal chain. And then make sure you have damages. Identify the actual harm suffered by the plaintiff, and make sure it's the type of harm that the law recognizes. Remember, negligence analysis is highly fact-specific. The same action might be negligent in one context, but perfectly reasonable in another. Context matters. Here's a quick hypo to bring it all together. Dr. Smith prescribes medication to patient Jones without checking his allergy history. Jones has a severe allergic reaction and sues for negligence. So let's break it down. 1. Duty. Well, yes, doctors owe patients a professional standard of care. 2. Breach. Well, likely yes. A reasonable doctor would check allergy history before prescribing medication. 3. Causation. Factually, but for the prescription, no reaction would have occurred. Proximately, an allergic reaction is a foreseeable consequence of prescribing medication without checking allergies. And 4. Damages. Well, yes, Jones suffered physical harm from the reaction. The result? Well, it looks like negligence to me. For deeper dives into these topics, check out our Listen and Learn series episodes on the reasonable person standard, special duties, causation, and negligence per se. Each episode walks through real bar exam questions with detailed analysis. All of these episodes are linked to in the show notes. In our next episode, we'll tackle intentional torts, the oldest and most straightforward category of torts, from battery and assault to defamation and trespass. We'll explore what makes these torts intentional and how to analyze them on exams. Thanks so much for watching. Be sure to give us a like, leave us a comment, and subscribe so you don't miss any future episodes.